Hello and welcome to Law Matters. My name is Michael Conroy and I am your host as we explore various legal topics that impact the lives of many of us or our friends or families on a daily basis. I am an attorney with the law firm of Hassett and George, a general practice law firm with offices in Simsbury and Cromwell, serving all of Connecticut. This program is informational and is not a substitute for legal advice. Each individual case is unique, and while we hope to inform and educate you regarding general legal issues, I cannot urge you strongly enough to seek competent legal representation if you are presented with a legal problem. Your rights and financial well-being could depend on it. If you have any questions, comments, or suggestions, or if you would like to request topics to be covered on future episodes, please email us at lawmatters@hgesq.com. On today's episode, we will discuss kids in trouble, with particular emphasis on the role technology can play. My guests today will be Assistant State's Attorney Debra Collins and my partner Ray Hassett of Hassett and George. In our ever more connected world, technology continues to be a bigger and bigger part of our daily lives. More than anyone, teens seem to be wired in almost every phase of their lives. While this can be useful for learning and staying in touch, it also creates a whole new world of potential problems that earlier generations never conceived of. Today we will discuss some of the ways that kids can get into trouble with technology, how to avoid these issues, and what to do if things go wrong. As I indicated, my first guest today is Attorney Debra Collins, who has been an Assistant State's Attorney for the state of Connecticut since 1997. She has prosecuted all types of criminal cases on behalf of the state and has developed a specialty in the area of sex offenses. She is a frequent lecturer to law enforcement agencies in many areas of criminal investigation and prosecution and has taught college courses on criminal law and juvenile justice. She is presently assigned to the Enfield Superior Court. She is married and the mother of 2 children. My other guest today is Ray Hassett, who is a founding member of Hassett and George. Attorney Hassett is a former federal prosecutor in Connecticut, where he served as a Special Assistant United States Attorney with the Department of Justice. For approximately the past 20 years, he has focused his private criminal defense practice on trial work, including state and federal representation. Ray was designated again as a super lawyer by Thomson Reuters Ratings Service as one of the top criminal attorneys in Connecticut. No more than 5% of the lawyers in the state are selected as super lawyers. Ray lives in Glastonbury with his wife and children. Debra, Ray, thanks for joining me here today.
Mike, thanks for having us. I think this is an exceptionally well-timed episode that we're going to have here today because it's very important. I find that in the criminal courts that these types of matters that we're going to talk about today are very prevalent, especially with kids, and I think that a lot of young people don't understand the ramifications. We're really fortunate that State's Attorney Gail Hardy permitted and allowed us to have an expert with us today, and that's Senior Assistant State's Attorney Deb Collins, who's here. And I think it's really important to get the state's perspective today on some of these issues. The first one I think that's important, Deb, and maybe you can comment on it, is the sexting that we're seeing going on, and maybe you can give us just a general understanding of how the state looks at these particular crimes, and they are crimes.
Well, actually, the state of Connecticut recently got more involved with the sexting stuff because what was happening is when kids were coming in originally with where you have, say, the 13-year-old dating the 15-year-old, which, you know, although I would not encourage, does happen, and you have the 13-year-old was sending a naked photo of themselves to the 15-year-old. The 15-year-old was receiving it, taking a picture of themselves and sending it back to the 13-year-old. We were finding that it actually does in fact qualify as child pornography, and that is both sending and receiving child pornography. And the problem with child pornography as it originally was is both first, second, and third degree all have mandatory minimum jail sentences, have mandatory registration as sex offenders, and they're all felonies. So again, there's a portion that when we get to the 17, 18, 19, you're still in the child pornography, but we realized that there was a big problem that how are we going to look at a 13, 14, 15-year-old and charge them with child pornography with mandatory minimum sentences. So the state of Connecticut did come up with a solution, but again, it certainly isn't the solution where we're going to ignore it. There's an actual statute now that's an A misdemeanor that basically says that kids from 13 to 17 cannot possess or send a photo of themselves to a 13 or 15-year-old without it being an A misdemeanor, which is still a year in jail, and that 13 to 15-year-olds can't send photos of themselves to anybody who's 13 and 17. So we at least took it out of the branding of the child pornography, but you're still looking at a misdemeanor, which again can easily jump from something that you could go to up to a year in jail for. And I think the problem is a lot of these kids aren't realizing it may seem like a photograph between each other and this is innocent fun, but the problem is, as we all know, dating relationships in the ages of 13 to 17 don't last very long. And when those relationships end is when you start having either the other kids, the young lady go to her parents and go, oh my God, he has naked pictures of me. They're running to the police, and we do have to prosecute. And again, it is an A misdemeanor, 1 year in jail, but that's for one photograph. Now talk if they've taken 50 photographs of themselves. Now you could be looking at 50 counts of misdemeanors.
And I know in the federal court system too, the number of photographs is really determinative as to how much time you're going to get and what your sentence ultimately is. So a pictures or a video or a movie can depict a lot of different sequential pictures, and as a result that can run into the calculations, which can be really problematic for defendants when it comes time for them looking at what their exposure is. I know that you've been dealing with a case recently regarding a video and underage or minors, basically underage adults, voluntarily in a video, taking the video and publishing it on the internet. Tell us a little bit about that, if you could.
Right. The problem with that particular case, and because it's pending, I obviously have to keep it very limited as what I can give as a factual basis. But generally, what it was two individuals having what we would say is consensual sex between each other. She was 13, he was 15. They had another individual videotape it. What ended happening was that when the relationship went sour, the videotape ended up on Facebook. The problem with that is now you've published it out to the world. Now we are jumping into child pornography, because the problem again with the misdemeanor sexting, it's between individuals who are all under the age of 17. But when it gets posted to Facebook, now you're talking all adult, and frankly the world can see it. And again, we still run into the problem where many kids don't understand that if I put it up on Facebook and I take it away 5 seconds later, then it's gone. It doesn't work that way. Once on Facebook, always on Facebook. And you don't know how many people have hit on that video and then spread. And that's what ended up happening, is it spread like wildfire. And again, these kids came in with these serious child pornography crimes, which they jumped right out of juvenile court, right into adult court, and we're looking really as charged as we stand today, could be a mandatory 1 year in jail of a sentence that's a D felony that also will require mandatory registration. And this was clearly something, when we met with the individuals and their attorneys, they were just stunned that it is child pornography. A picture or a video of a child under the age of 17, whether they did it consensually, whether they stripped down, whether they're posing, is still child pornography. And unfortunately, it just seems like kids these days don't understand that.
And Mike, there's a lot of side effects to this too that I'm seeing from my perspective. Remove the criminality from it and remove the aspects of potentially going to jail. You also have side effects of things like mandatory registration, as Debbie mentioned. You also may be excluded or precluded from the military, which is almost a guarantee. Colleges look at these. Sometimes they do background searches. If it's on Facebook or was on Facebook, you could expose yourself theoretically again to federal charges. So there's a lot of ramifications that are not even contemplated at the time that they're holding up that little cell phone or videotaping themselves, thinking they're doing it consensually, and there really isn't a problem with it. It truly does spiral very quickly. And fortunately, in Connecticut, we have some great prosecutors that understand the ramifications of what kids do. But they're very restricted as to what the law is at this time, and unfortunately there's only so much that they can do within the parameters of the law.
Right. Now, you both have mentioned mandatory registration. That's mandatory registration as a sex offender,
Correct.
right? Now, explain, if you would, what the ramifications of that might be in terms of real-world ramifications.
Well, I mean, the minimum, if you're required under certain crimes, if you're convicted, you must register as a sex offender, and that's a minimum of 10 years. So 10 years you are on the sex offender registration. It is published to all schools. I mean, there are parents that are restricted from picking up their children at schools because they're registered sex offenders. For these kids, you're looking at ramifications of not being admitted to colleges, because there's a lot of colleges that are certainly not going to allow somebody who's a registered sex offender to go on their campus. And we've seen where colleges are actually now searching kids' Facebook pages to see what's on their Facebook page. And so again, this innocent picture of you naked on your Facebook page that you sent to your boyfriend is now something where colleges are getting choosy now. They can pick and choose who they want to go to these colleges, and that may not be somebody that they want at their college.
I had a situation with a co-defendant in one of my cases that actually pled guilty to a sex offense and had mandatory registration, and I wanted to meet him and his lawyer at McDonald's. And when we got to McDonald's, he tapped on the window and told me to come outside, and I wondered why. So I went outside and I said, well, why don't you come on in and talk to us? Your lawyer's here. And he said, I can't go into McDonald's because there's young children there. The ramifications of registering as a sex offender and having restrictions on you go well beyond what you can even imagine. You can't even go to McDonald's unless you go through the drive-through. It's very, very, it can be overwhelming and is very pervasive on how it affects your life, where you live, what you do, where you work. It's a very serious thing that people don't even think about.
Plus, it's published. I mean, anyone, you could go tomorrow on your internet and look. All you have to do is put your street address, put in your street address, and it will tell you every registered sex offender in your neighborhood. So all your neighbors are going to know you're a registered sex offender. And we've had cases where there's actually crimes against those individuals because the neighbors are not happy that there's a registered sex offender. They don't care how you got that label, it's the fact that you have that label. So a registered sex offender of 10 years could be the young innocent kid that sent the sexting back and forth, or the actual individual who actually molested a child. You're still a registered sex offender.
So under the example you gave with the 13 and the 15-year-old, at the time, they might think that they're sort of immune to all of this. And then one of them posts something on Facebook. You could be looking at a 13 or a 15-year-old being required to register as a sex offender.
You could. You could. I mean, I would hope most prosecutors like myself would take everything into consideration, but you definitely could. And I think the other point I was going to touch on is, what do you do when the 16 or 15-year-old is dating the 18-year-old, which does happen in our high schools if you have the freshman dating the senior or the sophomore dating the senior or somebody that's been held back. The 18-year-old does not fall under the new law. So therefore, they are in the child pornography. So you may have the 15-year-old that takes the naked picture of herself and sends it to the 18-year-old. She's committed an A misdemeanor. When he receives that photograph, he's now has the D felony with the mandatory 1-year mandatory minimum.
Wow. And technology isn't just limited to sexting when we see these issues that are popping up in court. There's a number of issues, for example, of people surfing the net and pulling up pictures. And one of the things that I counsel my young clients about is that when you go on the internet and you pull up a picture, regardless of what type of pornographic picture it is, if it's child pornography or deemed to be child pornography, the simple fact by you opening it technically is a violation of the law. And most people say, well, I just opened it, or I opened it inadvertently and I deleted it. Well, as we know, deleted items don't always get deleted, and they're usually there. Forensically, the state police, I know, and the FBI have access to equipment that they can access all of this information to the extent that they want to. So the simple fact that you opened up a document that contains child pornography on it, even unbeknownst to you, theoretically could be a violation of the law. And unfortunately, we are seeing more and more cases of people being arrested for child pornography. Now, usually those are the serial offenders, but everyone has to be cautious of opening up something on the internet that truly they don't know where it came from or they don't know what it is. I don't know if you're seeing that much with respect to the child pornography cases that you're handling with, but I'm seeing more and more of it.
We are a little. I mean, most of our concentration is for the people that, we see the repetitive nature of them going into child pornography. But to touch on the opening photographs or putting photographs on Facebook, I do handle all the sex assaults in Enfield, or really in the Enfield jurisdiction, which includes many towns. But what I think a lot of parents, just touching on the whole Facebook and putting pictures up, we often see, and I often give this lecture to my daughter's teams when we meet with parents and stuff, that a lot of people don't understand that Facebook is so accessible. And if you two were to put pictures of your children, very cute pictures in their bikinis on the beach, oh, aren't they cute? We're seeing a lot of pedophiles that are surfing Facebook, taking those pictures, downloading them, and then either transposing them on naked bodies with your child's head with a naked body of a picture from their child pornography, or vice versa, where it's your child's body with one of their victims. And books that they have or on their computer, when we do search their computer, and we have to go back and go, this isn't your child, right? But it's the cutting and pasting that they do, that parents really should think twice before putting any pictures of their children on the internet. I'm just very anti it, and basically because I'm the one having to go through these photographs, or sometimes having to reach out to these parents to go, this isn't your child, right? And we're relieved to find out it's a cutting and pasting situation and not an actual molestation of their child. But I think it just goes to the fact that when we do these search warrants, we're seeing a lot more of that, where they're cutting and pasting, that the general population's giving them the photographs to use, and then they're just cutting and pasting to their likes and dislikes.
One of the things that you also mentioned with respect to your expertise is in the area of sexual assaults. And one of the statutes that we have on the books now deals with the age differential between, like you said, the seniors and the freshmen and so forth. And what a lot of young adults don't realize, and kids in school don't realize, is they could have consensual sex with a minor where obviously both parties are participating and understand the ramifications, and yet one of them has committed the old statutory rape, which is now a sexual assault. Touch on that a little bit on what you're seeing.
Right. I think the problem with the word consensual, there's the consensual, that layman's term that we both agree that we want to do something, versus consensual legally is the problem. What we're seeing is sexual assault in the second degree, which is in fact you could get up to 20 years in jail, 9 months of it, which is mandatory minimum time that you will have to serve for committing sexual assault in the second degree, is if the victim is between the ages of 13 and 15, and that can be male or female, and the perpetrator, or the person that's alleged to commit the crime, is greater than 3 years older. So what you could have is a 14-year-old dating an 18-year-old. Completely, the parents love them, they think they're a great couple. A lot of 18-year-old, for example, boys are very immature, so the parents are thinking this is, we have no problem with this. But it's when the relationship breaks up that all the parents are running to the police department saying, she's only 14, he's 18, it's more than 3 years. And the other problem we see too is it's 365 days times 3 for the 3 years. Mm-hmm. So a lot of times with birthdays, kids could look like they're only a 15, 18-year-old gap. Or for example, a situation where one has been held back or one was ahead and they look like they're in the same grade, but they're not. So I think every parent, no matter who your child is, deciding to date, you have to be upfront with them and make sure that that age gap, whether you are fine with the age gap or not, the law may not be fine. And when the relationship breaks up, which many, teen relationships do, there is the problem that if they walk into our police department and we see that the victim is between 13 and 15 and the person alleged to have sexual relations with them is more than 3 years, and that could be 3 years in one day, we have to arrest for sex assault in the second degree.
So that's the example that you gave earlier. You could have the senior dating the freshman or sophomore, things go sour, and the senior could be looking at 20 years.
20 years.
And mandatory registration and everything that goes along
Right, and everything that goes with it.
So, and there's not a lot of discretion that's allowed in the law. It's pretty pretty severe and pretty strict.
Well, I think, too, they don't even realize with sex assault in the fourth degree, which is just sexual contact. That's not actual sexual intercourse, but actual just sexual contact. If the victim's under 13, the person that's having that sexual contact cannot be more than 2 years older, or that's sex assault in the fourth degree. And again, you're looking at all the ramifications that come with that. And do you really want a criminal record of sex assault in the fourth degree?
And I'll complicate it even one step further, and that is,
Please do.
if in fact, for some reason, the individual is not an American citizen, is here on a visa or resident alien or some other status other than being an American citizen, they will be deported, and there's not a lot of discretion in that either. They'll be picked up by an ICE agent, which is an immigration customs agent, and they will be brought up to Massachusetts. They will be held in a federal facility. They will have a fairly quick hearing and be deported. There is very little that can be done to stop that if there's a finding of guilt or a plea of guilt. Someone pleads to guilty to one of those offenses. It's an automatic under the federal statute. So. There's all kinds of complications, again, that arise from these charges, these allegations that people don't contemplate at all. Now, one of the things that we were talking about prior to the taping here today, and I know Debbie feels very strongly about this, is the texting and driving that the kids are doing today. And maybe you could give us a little idea of what the state's position. We know is takes this very seriously, and young people don't realize the ramifications of it. And what are you seeing?
Well, I mean, I'm very proud that the state of Connecticut does take a zero stance on it. No one can text and drive. No one, not adult, not kids. But Connecticut went a step further and said even the hands-free device, that it's illegal for anyone under the age of 18 to use the hands-free device. And I don't think a lot of kids know that. I think they think, okay, we'll buy, our young child the hands-free device and they'll be fine because most of the cars have the whole Bluetooth apparatus in it. But if you're under the age of 18, you can't even use the hands-free device. And it ends up with a 30-day license suspension and a $100 fine for each time you do it.
So if you're under 18, even if you're driving along hands-free, Mom calls you, stop by the store, pick up a gallon of milk, that's an offense right there.
Correct.
Okay.
So there's a couple other things that I think we should talk about while we have some time, and that is, I know that there's new regulations and new statutes regarding bullying, and I'm not sure what the prosecutor's position is on that. I know what the law requires, but the state's attorney's office is getting more and more of those cases, as I understand, as well.
Well, I think unfortunately sometimes Facebook's being used as a tool for bullying, and we do see that a lot lately, where I don't think people realize with bullying, it really is a situation where if you're going after someone for either sexual orientation, race, gender, anything, it really can affect the person. We've seen deaths resulted from it, both adults and children, and I think Connecticut is taking this strong position where not only are we having where schools have to investigate now any complaint that is made, but I think they are really looking towards Facebook to see, just because you're doing it on Facebook, they're pulling it back to the school and say, you know what, if you're going after one of our classmates within that realm, we are going to look into it, and we definitely would prosecute for it.
Well, you told me a funny story one day. Not funny, but a story one day about how you had a particular defendant that was claiming to be not guilty of an offense, and you actually pulled up their Facebook and found some evidence.
We do a lot, and I like to warn defendants of that. We've had people that have videotaped their crimes and put it on Facebook. We had they were knocking over mailboxes, I believe in Simsbury. Videotaped the entire thing. We could have never proven it without the aid of their Facebook page. We also have defendants who claim one thing and then they go on their Facebook page and we find out it's something else, whether it be that they were falsely accusing someone or they admit that they had done something, or they'll be in court seeming, just the nicest person in the world. And I actually had a defendant go on Facebook and just lambaste me and the judge, so that his next arraignment, we made sure to let his honor know what he had put on his Facebook page. So we do watch Facebook, both our police officers and our prosecutor's office, just to keep an eye out. So, be careful what you put on there.
And it's amazing what people think won't be seen by others, but
Right.
it's an investigative gold mine, I'm
It
sure,
is.
for
It
you,
really
as it is in the civil realm as well.
Yeah.
We're all familiar with the DWI laws too, and I think that our school systems and our, at least my experience has been with my kids, the driver's education courses provide very good education on that, but we can't reiterate it enough about the zero tolerance rules when it comes to alcohol and driving. And maybe you can touch a little bit on that too.
Sure. We do take a zero tolerance. 16 and 17, they'll lose their license for a year if they take the test, meaning the breathalyzer test. If they refuse to take the breathalyzer, it's an 18 months license suspension, which I know most parents don't want to be driving around their 16 and 17-year-olds. The alcohol education program, as you know, can be as much as $700 to do, take up to a year. So we do take a zero tolerance with anyone under the age, obviously, of 21 with DWI. But I think there's also the binders with passengers laws, too, that I think a lot of people don't realize, that we're also doing a lot of license suspensions with that, where they violate the, right now, their first 6 months you can have no passengers under your driver's license. Second 6 months, immediate family only. And that a lot of people don't realize there's a curfew till you're 18 between the times of 11 p.m. to 5 a.m. And the license suspensions with all of those if you violate.
And as a parent, I can say thank God for that 11 o'clock deadline. But it is something that I'm seeing more and more of, that people are in fact aware that the laws are out there. I think that a lot of credit goes to our school systems, that kids are being educated on this particular topic. So I don't know if we need to spend a lot of time on it, Mike, but it is important, obviously, to reiterate it, since it can be the difference between life and death. The other topics that we talked upon, again, very, very important, and I think for the most part it needs to be education that we need to provide. I think having Attorney Collins here today on behalf of the state, I think is just a wonderful step that in the education process. I think it's wonderful that we have opportunities like this to hear from people that are experts in this area, and they can provide us with some good, solid information on how to avoid these type of legal complications.
It really is. And I'd like to thank you again for joining us here today, Debra.
Sure.
We could go on for quite a while on all these topics, I'm
Right.
sure, but unfortunately that's all the time we have for today. We hope you found the show helpful and informative. This program has been intended for informational purposes and is not a substitute for legal advice regarding your particular situation. From all of us at Law Matters, thanks for watching.
Funding for Simsbury Community Television is provided in part by contributions from viewers like you. Thank you.